Figuring out how India's states are run, well, it can feel like a real puzzle sometimes, can't it?
It really can. So many layers.
Exactly. So today, we're zeroing in on two absolutely vital pieces, the chief minister and their council of ministers.
Yeah, the real engine room of state government.
We've got a great set of sources to unpack this constitutional analyses, guides on how governments form, even a look at the governor's powers. Should be interesting.
Definitely. Our goal in this deep dive is really to get under the hood, understand the constitutional framework for these roles in the states. We're drawing on iPleaders, some general government resources,
Yeah.
Wikipedia, Deccan Herald, Drishti IS.
And even info from a Raj Pavan site. So, a good mix.
A very good mix. We want to give you a clear picture, appointment, powers, responsibilities, maybe some surprising bits too.
Okay, let's unpack this. Where does the blueprint for all this actually come from in the first place? The Constitution, I assume.
Absolutely. The foundation, as always, is the Constitution. And for the states, Article 164 is really the key provision here.
Article 164?
It lays down the rules for the chief minister and the council of ministers at the state level. It's basically the state counterpart to Article 75 for the central government.
Okay, so 164 is our main focus. But I remember something about the governor needing advice. That's relevant too, isn't it?
Oh, definitely. That's Article 163. It says there has to be a council of ministers with the chief minister at the head, specifically to aid and advise the governor.
Aid and advise. Key phrase.
Crucial. Except, of course, in those, very limited areas where the Constitution lets the governor use their own discretion. But mostly, it's aid and advise. And all this is in Part 6 of the Constitution, the part dealing with the states.
Right, Part 6. Okay, so the chief minister gets appointed. How does that actually work? Because, we don't vote directly for a CM in state elections, do we?
No, you don't. The appointment itself is made by the governor. That's what Article 164 says.
Okay.
But while the governor has the formal power, there's a very strong convention in our parliamentary system.
Ah, the convention.
Exactly. The governor almost always appoints the leader of the party or the coalition that has the clear majority in the state legislative assembly.
Right, that makes sense. But what if it's messy? Hung assembly, no clear winner. We see that happen.
Yeah, and that's where it gets, a bit more complex. If no single party gets that majority, the governor has some discretion.
Okay, so what can they do?
They might invite the leader of the single largest party. Or they might look at a post-election coalition and invite the leader who seems most likely to command a majority.
And then they have to prove it, right?
Precisely. When the situation isn't clear-cut, the governor will usually ask the appointed chief minister to prove their majority on the floor of the assembly, usually within a set time. That's the confidence vote.
Okay. Now, what about this scenario? Someone who isn't even an elected MLA gets appointed CM. Can that happen?
Yes, it can. Someone who isn't currently a member of the state legislature can be appointed chief minister.
Really?
But, and this is a big but, there's a strict condition attached. They absolutely must get elected to the legislature, assembly, or council if the state has one within 6 months.
6 months.
If they don't manage that within 6 months, they have to step down. No ifs, ands, or buts.
Right, hard deadline. Makes sense. Okay, so that's the CM. What about the rest of the team, the council of ministers? How are they picked?
Again, Article 164,
What?
specifically 164.1, covers this. The other ministers, they're appointed by the governor, but only on the advice of the chief minister.
Ah, so the CM chooses their team.
Essentially, yes. The CM decides who they want, recommends them, and the governor makes the formal appointment. And like CM, these ministers are usually MLAs or MLCs, but again, a non-legislator can be appointed.
With the 6-month rule applying to them, too.
Exactly. Same rule. Get elected within 6 months or you're out.
So the CM really has a lot of say over who's in their cabinet. What are the actual baseline requirements to even be considered for chief minister?
The eligibility. It's pretty straightforward, actually. First, you need to be a citizen of India. Obvious, but important.
Right.
Second, at least 25 years old. And third, as we've just discussed, you have to be a member of the state legislature, or you have that 6-month window to become one after being appointed.
Okay, citizen, 25, and member of the legislature, or soon to be. Got it. So we've covered appointments, eligibility. Let's dive into what a chief minister actually does. Their powers, functions. What's the core role?
Fundamentally, the chief minister is the head of the state government. They hold the de facto executive power. They're the real leader.
De facto. Okay, so in practice.
In practice, yeah. They recommend people to the governor for appointment as ministers. Then, crucially, they decide who gets which department they allocate the portfolios. And they can reshuffle them later if needed.
So they control the team structure. What if a minister isn't performing?
The CM has options. They can ask that minister to resign, or they can go a step further and advise the governor to actually dismiss the minister. So yeah, they manage the team.
So they're definitely the captain. What about the day-to-day running of the government?
Absolutely central. The CM presides over the meetings of the Council of Ministers. They heavily influence the decisions made there, guide the discussions, and make sure all the different ministers and departments are working together, coordinating.
It sounds like a huge coordinating role.
It is. And here's something that shows just how central they are. If the chief minister resigns, or sadly, if they pass away, the entire Council of Ministers automatically dissolves.
Wow, the whole thing collapses.
The whole thing. It highlights their pivotal position.
That's a massive responsibility. What about the link between the CM and the governor? How does that relationship work?
The CM is the main channel of communication. Article 167 spells out these duties quite clearly.
Article 167, okay.
The CM has to keep the governor informed about all council decisions regarding administration and proposed laws. They also have to provide any information the governor asks for.
So it's an obligation to keep the governor in the loop.
Yes. And interestingly, if a single minister makes a decision, but the whole council hasn't considered it yet, the governor can actually require the CM to put that matter before the entire council.
So the governor can ensure collective consideration sometime.
Exactly. It ensures decisions aren't just made in silos.
It seems like a constant flow of info. Now, what about the state legislature? The assembly? What's the CM's role there?
Very important. The CM advises the governor on when to call the legislature into session or when to prorogue it, which means ending a session.
Prorogue, right.
They can also recommend dissolving the assembly entirely, which triggers new elections. And of course, on the floor of the House, it's usually the chief minister who announces the government's major policies and defends its actions. They're the primary spokesperson in the legislature.
So advising on sessions, dissolution being the main voice, quite involved. Any other big roles they often hold?
Yes, quite a few often come with the job. They're typically the chairperson of the State Planning Board. They also serve as a vice chairperson of the relevant zonal council, usually on a rotational basis.
Yeah, no councils, okay.
And they're members of national bodies like the Interstate Council and the Governing Council of NEOYOG, both chaired by the Prime Minister. Plus, you could say they're the state's chief spokesperson to the wider world and the main crisis manager in emergencies.
Okay, CM is definitely the linchpin. Let's shift focus a bit to the Council of Ministers as a whole. You mentioned size limits earlier.
Yes, there are constitutional limits. The 91st Amendment Act from 2003 put a cap in place via Article 164(1)(a).
And that cap is?
The total number of ministers, including the chief minister, cannot exceed 15% of the total strength of the state legislative assembly.
15%, okay. Is there a minimum?
Yes, there is. The same clause says the number of ministers, again, including the CM, cannot be less than 12. This ensures even states with smaller assemblies have a functional council.
All right, so between 12 and 15% of the assembly size. Interesting. Now, we hear different titles, cabinet minister, minister of state. What's the difference?
Good question. The council isn't monolithic. You generally have 3 ranks. Cabinet ministers are the top tier. They usually head the major government departments, attend all cabinet meetings, and are central to policymaking.
The core team.
Exactly. Then you have ministers of state. They might have independent charge of smaller departments, or they might be attached to a cabinet minister to assist them.
Okay.
And sometimes you have deputy ministers who generally assist either cabinet ministers or ministers of state with their duties. They aren't usually part of the cabinet meetings themselves.
And you mentioned deputy chief ministers earlier, too.
Right. Some states have them. It's not a constitutional post, more of a political arrangement, but they exist, often senior figures.
Okay. How does this group, the cabinet mainly, actually make decisions? Is it just in the main meetings?
Often, a lot of the detailed work happens in cabinet committees. The chief minister sets these up.
Committees?
Yeah.
Like standing ones?
Could be standing committees, which are more permanent, dealing with specific areas like, say, economic affairs or political affairs. Or they can be ad hoc temporary ones set up to tackle a specific current issue. They do the groundwork, discuss details, maybe draft proposals, which then go to the full cabinet for the final decision.
Makes sense. Streamlines things. We've talked powers.
Yeah.
What about responsibilities? I know collective responsibility is a big one. What does that mean in practice?
It's absolutely fundamental. Article 1642 enshrines it. Collective responsibility means the entire Council of Ministers is jointly responsible to the state legislative assembly for everything the government does. They swim or sink together.
Swim or sink together. So if the assembly loses faith,
If the assembly passes a vote of no confidence in the government, the whole council, CM included, must resign. That's the ultimate enforcement of collective responsibility.
so one failure brings everyone down. Powerful idea.
Very. Or the flip side is, if the council feels it's lost the assembly's confidence and perhaps the assembly doesn't reflect the public mood anymore, they can advise the governor to dissolve the assembly and call fresh elections.
Okay, so it works both ways. Is there also individual responsibility for ministers?
Yes, there is. Alongside collective responsibility, Article 164 also implies individual responsibility. Technically, ministers hold office during the pleasure of the governor.
Pleasure of the governor.
Hmm?
It sounds like the governor could just fire them.
Well, that's the wording. But in practice, as we discussed with CM appointment, convention and judicial interpretation are key. The governor exercises this pleasure almost exclusively on the advice of the chief minister.
Ah, so it comes back to the CM again.
Exactly. It reinforces the CM's leadership. If the CM isn't happy with the minister, they'll ask them to resign or advise the governor to remove them. It keeps the team aligned.
Got it. Now, one thing I've wondered, are ministers legally liable for their official decisions? Like, can you sue a minister personally over a policy?
That's an interesting point. The Constitution, at the state level, just like at the center, doesn't provide for legal responsibility in that way. No. There's no requirement for a minister's signature to make a governor's order legally valid. And crucially, the courts are explicitly barred from inquiring into the nature of the advice given by ministers to the governor.
Why is that?
It protects the internal workings of the executive and maintains the separation of powers. It prevents the government from being constantly tied up in court over advice given in confidence.
Interesting protection. Okay, what about actually taking office? There's an oath, right?
Yes, absolutely. Before starting their duties, the chief minister and every other minister have to take 2 oaths, administered by the governor, an oath of office, and an oath of secrecy.
2 oaths. And the wording is set out somewhere.
Yes, the exact forms for these oaths are laid out in the 3rd schedule of the Constitution.
What do they actually promise in these oaths?
The oath of office is about commitment, pledging true faith and allegiance to the Constitution, upholding India's sovereignty and integrity, faithfully and conscientiously doing their duties,
Okay.
and doing right by all people, according to the Constitution and law, without fear or favor, affection, or ill will. Pretty comprehensive.
That sounds it. And the oath of secrecy.
That's about confidentiality. They promise not to directly or indirectly reveal any matter brought under their consideration or known to them as a minister, except as may be required for the due discharge of their duties.
Right. Keeping government business confidential.
Yeah.
How long do they typically serve? Is it a fixed term, like the Assembly's 5 years?
No, their term isn't fixed in the Constitution. It really depends on one thing, maintaining the confidence of the Legislative Assembly.
So as long as they have the majority support.
Exactly. If they lose that support, usually shown by losing a no-confidence vote, they have to resign. The governor can also dismiss them if it's clear they've lost the majority. Their term is tied to political support, not the calendar.
And their pay. Who decides that?
Their salaries and allowances are determined by the state legislature itself through legislation.
Okay. Now let's touch on something that often grabs headlines. Disqualification. Especially this anti-defection law stuff. How does that affect ministers?
Right. The 91st Amendment Act, the same one that set size limits, also tightened things up here. Article 164 1B is key.
64(1)B, and it says,
It directly links disqualification as a legislator under the 10th schedule, that's the anti-defection law, added by the 52nd Amendment in 85, to being disqualified from holding office as a minister.
so if you're disqualified as an MLA for defecting,
You are also disqualified from being appointed or continuing as a minister, including chief minister. This disqualification lasts for the rest of that legislative term or until you contest and win a fresh election, whichever comes first.
so defecting basically blocks you from ministerial posts for that term. What exactly counts as defection? Briefly.
Well, basically, 2 main things. If a legislator voluntarily gives up membership of the party whose ticket they were elected on, or if they vote or abstain from voting in the legislature contrary to a direction, a whip, issued by their political party.
Going against the party line on a key vote.
Exactly. The idea is to curb political instability caused by legislators switching sides for personal gain.
Are there any loopholes, any exceptions where it doesn't apply?
There's a major exception: party mergers. If an original political party merges with another party, and at least 2/3 of the legislators belonging to that original party agree to the merger,
It's 2/3, okay.
then neither the members who join the merged party nor those who might remain in the original party are disqualified. It allows for larger political realignments without triggering defections.
Right, that makes sense for genuine party shifts. Okay, let's circle back to the governor's power to dismiss a minister. We touched on it, but it seems like a sensitive point. How real is that power?
It is sensitive, and you're right to focus on it. While Article 164(1) says ministers hold office during the pleasure of the governor, the key takeaway from our sources and from constitutional practice is that this power is almost always exercised only on the advice of the chief minister.
So the pleasure isn't the governor's personal feeling.
Not in that sense, no. It's constitutionally conditioned. We need to remember the history. The Government of India Act, 1935, gave governors much wider discretionary powers.
Right, pre-independence.
Exactly. Our Constitution deliberately moved away from that, strengthening the elected executive, the chief minister, and the council. The power shifted.
And courts have confirmed this.
Yes. Landmark Supreme Court judgments like Shamsher Singh and Nabam Rebia have repeatedly emphasized that the governor's executive powers are generally bound by the aid and advice of the Council of Ministers.
So a governor dismissing a minister without the CM's advice would be problematic.
Highly problematic. It would likely be seen as a constitutional misadventure, undermining the chief minister, potentially destabilizing the state government, and upsetting the federal balance. It's generally understood that the governor's pleasure is exercised through the CM's advice in this context.
Okay, so the CM's recommendation is really paramount there. One last role of the deputy chief minister, we see them in various states. Is that position actually in the Constitution?
No, it's not. The post of deputy chief minister isn't mentioned anywhere in the Constitution itself.
So why do we have him?
It's essentially a political creation. It often emerges in coalition governments to accommodate a major partner, or sometimes within a large single party to manage different factions or reward a senior leader.
A political balancing act.
Pretty much. They might chair cabinet meetings if the CM is absent or lead the House, but their powers are generally those assigned by the chief minister. It's about political management, not a distinct constitutional office.
This has been incredibly helpful, really clarifying things. So just to quickly wrap up the main points for everyone listening, the chief minister is the real center of executive power in a state. Appointed by the governor, yes, but almost always the leader commanding a majority in the assembly.
Right, and the Council of Ministers works under that principle of collective responsibility to the assembly they stand or fall together, and also individual responsibility, but mainly through the CM's guidance to the governor.
And the governor's role, while constitutionally defined, is largely exercised on the CM's advice, especially regarding appointments and dismissals. Plus, that anti-defection law adds a layer restricting who can be a minister if they've been disqualified as a legislator.
Exactly. And maybe one aha moment, if you like, is really grasping that evolution of the governor's power. Seeing how it shifted from the more discretionary role under the British-era 1935 Act to the current system, where the elected CM's advice is paramount, that really highlights the strengthening of democratic governance in our federal structure. It wasn't just copied, it was adapted.
That's a fantastic point, the deliberate shift towards elected power. Okay, so here's a final thought for you to ponder. We see this complex balance. CM, council, governor. With politics constantly evolving, more coalition governments, different dynamics. How might these constitutional articles be tested or reinterpreted in the future?
A good question.
What could that mean for how stable, how effective state governments actually are? Definitely something worth keeping an eye on as you follow state-level politics. Thanks for joining us for this deep dive.